And let's bring in some legal perspective too with regards to those proceedings. President Cyril Ramaphosa's bid to have that private prosecution case by former President Jacob Zuma to be dismissed. Legal transformation practitioner Thabo Masombuka now joins us via Zoom. A very good afternoon to you. Thank you so very much for giving us your time this afternoon. It's good to see you in the new year, sir.
Good afternoon. Compliments of the floor and your viewers.
All right, let's talk about this then, Thabo. I want your thoughts really on the arguments that were sort of presented by both sides today when it came to this urgent interdict. What did you think about those arguments?
Look, thanks, Flo, and your viewers. The arguments in courts today puts into test at least two legal principles. One, whether or not a civil court has jurisdiction or authority to interfere with the work of another branch of the judicial system, which is a criminal court. So in other words, an accused before another court be able to successfully approach another court, which is a civil court, and seek legal remedy to stop prosecution, whether private or public, in another court. And secondly, whether or not that can be done on an urgent basis. If you listen to today's argument, Zuma's representatives seems to argue that Mr. Ramaphosa is using his office as the president to seek urgent legal relief. And the debate is whether or not the president is also accessible or entitled to protection of the law and the constitution. And that's where the judgment on Monday is going to be interesting in determining whether or not everyone is equal before the law in that respect.
And would you think that the applicant, of course in this case President Cyril Ramaphosa, that the applicant has sort of succeeded in proving that there is no way for him to obtain that substantial redress in due course, as is one of the requirements for the application for urgent interdict to succeed? Has he been able to prove that in fact?
Based on the argument presented before court, and there are usually a set of requirements that are set to prove urgent relief. Firstly, is that the applicant would suffer irreparable harm if the order is not granted, and that there's not alternative relief available to him or her at his disposal, and that his constitutional or legal right of protection is in serious jeopardy if that relief is not granted. To a certain extent, that argument was placed before court. The Zuma's argument is that the harm is done already because the charge has been placed. Mr. Ramaphosa has to appear before court. And the counter argument to that is that the summons that places or that seeks to invite Mr. Ramaphosa before the court on the 19th is in itself constitutionally invalid and legally unenforceable. And therefore, that's what left with no option but to approach this full bench of the High Court. In fact, we must, also make judicial notice of the fact that this becomes now a full bench of the High Court instead of a single judge. It tells you the seriousness and the urgency of this matter and the gravity of the judgment, should the judgment be made. There is something, however, very disturbing that was made as an argument by the Zuma's counsel today. And the nonsensicality, it is baffling that Mr. Ramaphosa's summons to appear in court is in respect of something so-called accessory to the fact. If you look at the legal definition of what an accessory to the fact is that you must have been willfully, knowingly aided someone who has committed an offense. The facts in this matter does not suggest that. But more importantly, they say Mr. Ramaphosa argues today as a juristic personality, meaning as the office of the president, and yet he's actually being charged as Cyril Ramaphosa as an individual. And yet the so-called allegations about accessory to the fact relate to Mr. Ramaphosa having, according to them, failed to exercise his responsibility as the president after Zuma has written to him to do so. The contradictory nature of that argument make it highly nonsensical, to say the least.
Mr. Masombuka, let's talk about this issue of relief and alternative relief. The fact that the president's legal team has said that there would be no other relief, no alternative relief available to the president. Is it true, though, to say that? Wouldn't the other relief be to indeed then defend the matter?
What the harm, according to the argument, is not whether or not there are prospects of success for Mr. Ramaphosa to appear in court, but the very appearance in court is actually, according to them, the very harm. Because to subject the head of state, the president of the country, to a private prosecution matter where he is not even alleged to have been the primary participant in the act. Because what is the unlawfulness here? Unlawfulness flow is the so-called distribution or public availability of medical record of
But you talk
Zuma.
about equal before the law. How is that a justification that, you know, a president shouldn't be hauled before the courts? And I'm sure we've actually seen that happen in the country. How is that a viable explanation? How is that a viable legal explanation that someone shouldn't be hauled in front of a court for a particular reason of their position in society? Are we not arguing the fact that we're talking about equality before the law?
Equality before the law is sacrosanct, applicable to everyone. But remember, the very same legal counsel for the respondent comes today and say the president uses his proximity to authority to trump an article. So in other words, the very same argument now is self-defeating, because you're saying, yes, everyone is equal to the law, but you can't be more equal to the law than the others. But here's the issue. Of the allegation here is that there is a criminal contravention. And what is the criminal contravention? Is that public medical records were made public by a journalist in collaboration with a prosecutor, right? And now you want to subject a head of state and a president to a private prosecution proceedings on the basis of the fact that you believe that they have not acted on the letter that you have written to them seeking protection. Let's even assume that, and I heard your analyst saying, President actually wrote to the Minister of Justice and the LPC. Let's assume that the President did actually nothing about that letter. In the worst case scenario, the President never wrote a letter, never actioned that. That still wouldn't warrant the complainant in this matter to have publicly drawn or dragged the head of state to private prosecution proceedings in what is called flimsy and legally questionable summons. So that is the harm here. The harm is not whether or not there are prospects of success in the defense. The harm is the very act of subjecting the president in what is otherwise a flimsy act of private prosecution.
All right, let's leave it there. Thank you very much to you. That is legal transformation practitioner Thabo Masombuka joining us live via Zoom there. Thank you for your time, sir.